Welcome to Casualty Connect, our video series at the intersection between artificial intelligence and the property and casualty insurance industry. I am Frank Giaoui, the founder and CEO of Optimalex, and today with me is Tom Geroulo. Hello, Tom.
Hello, Frank.
Tom, you are an attorney and partner at BBC law firm. You are specializing in complex claims litigation. And I would like to start the discussion with you with your views on what are the challenges in today's litigation for how economic medical damages and also non-economic damages are calculated.
Sure. Well, Frank, first of all, thanks for having me on. I really appreciate it. In trying to break down these categories, there's a lot of challenges. Damages are, a big deal these days, and it's where I spend all sort of my professional time, right? On the economic side, it's all about data and where that data comes from, right? We have a long-standing sort of battle going on and have for decades about the differences between what is billed for a medical service and certainly what is paid for a medical service, right? That discrepancy is often large. That debate is equally large inside the courtroom. And on that specific issue, we have courts that just treat that issue differently all across the country. So you might be in California where you have a statutory scheme for medical malpractice cases that encourages more of the what is been paid for a medical service as a measure of damages. But then you might be in a case in Illinois where you can't discuss that at all, or at least that's the initial position of the courts. That difference between what is billed for a service and what is paid for a service leads to, an extraordinary amount of debate on economic damages. It's a very big deal. The the other sort of dominating issue these days are claims about inflation in healthcare costs and inflation in general, especially in the American economy. It's been a popular political issue that spills over into the courtroom and a presumption that you have inflation in medical services. The pushback that we have to that is advancement in medical technology, medical services, medical treatment might lead to better outcomes, which lead to less treatment in the future, and that applying inflation across the board may not be applicable. Again, that's a fight we have just about every day. And, that all gets tied into how expert witnesses present their cases, life care planners, economists, the data that they rely upon in putting forth their damages models, and the data that we rely upon in responding to those and putting on our own damages models. That's kind of the economic end of things. On the non-economic end, we have just all kinds of approaches, right? There are seminars, courses, workshops devoted to how to present non-economic damages on both sides of the equation. And I think some of the things that, often get influenced or often cause influence in these cases are comparisons to life situations that are made by trial lawyers, where they say something along the lines of, baseball player makes $300 million over the course of 10 years, for swinging a bat. Don't you think somebody's life is worth more than that? Which isn't entirely empirical, but is a very common sort of refrain. I think on the defense end of things, when I'm involved in sort of these non-economic damages issues, the most important thing to look at, or really two things, are themes and specifics. By themes, I mean understanding this human being's life, what it was, what it is, and what it might be, and making sure you're really addressing the person and doing so in a dignified way that reflects what you've learned about their life and the best that you can learn about their future. And then by specifics, that is going through the case, going through discovery, and really learning about them and asking them, what is it you are hoping for? What is it that you are looking for? What is it that you need? What is it that folks say that you need who are giving you advice, medical professionals and others? And beginning to identify and outline the real world costs of that. And, my experience is increasingly that when you get to those specifics and when you spend time on them and identify those costs, you can begin to build reasonable non-economic compensation comparisons that match real life a little bit better than necessarily drawing a comparison to non-economic damages that are given, with baseball players or movie stars or other real world kind of hypotheticals that folks try to put out at trial.
Thank you, Tom. So you kind of anticipated my next question. You started by saying, well, it's all about data. So my question is, what types of information are needed in the litigation to better evaluate both the economic and the non-economic damages?
Yeah, so there's just an increasing amount of it that is available, right? And so we'll start on kind of the healthcare end of things, and that is one area where it's very easy to identify. Historically, when presenting these cases, you would see here is a life care planner for the plaintiff, here is a life care planner for the defendant. They have researched their costs through the traditional life care planning methods and presented that, and you have a delta between them. Somebody might have a $10 million life care plan, and the defense might have a $5 million life care plan. And that data has historically come from reaching out to providers and asking what they charge. Today, there's such a wide variety of sources that were not available even 5 years ago that are now. Healthcare price transparency has been a big change for this area of the law. Hospitals are now publishing data that they didn't have to publish before, that wasn't publicly available before, that helps you identify daily rates in a hospital, specific surgeries, specific therapies, lots of different things that now present cash prices for medical services that simply wasn't available 5 years ago. Getting through that data is a challenge, but it is possible. And it's the type of thing that you're looking for. Making sure that you are looking for insurance-based information is super important. I bore a lot of my business partners and colleagues by how much I talk about liens and how important they are for learning about a given plaintiff in a given case, but they're rather valuable data that is often left to the end of the case rather than the beginning of the case, where it could be a lot more helpful. On the non-economic end of things, just to kind of keep that balance going in our discussion here, I really return to what I said earlier, where you're trying to learn everything you can about the person, the family, who they were, and who they are, and who they're going to be. And some of the data is boring, but it's very necessary. You want to make sure you're spending your time, collecting relevant information about what they filed in their taxes, right? What they sort of prepared for their life, if they're in the middle or near the end of their life. Have they set up things for themselves, retirements and other, planning instruments? What is it like for them to pay their mortgage? What is it like for them to pay, for their car insurance? You want to get these sort of regular everyday details. And then you also want to be looking for some of the aspirational things. What are the things that you would still like to do? What are the things that make you feel good? What are the things that bring you joy and happiness specifically, so that you can learn about it? And somebody might say, we really like to go to Disney World every year. That's something that we do. It's become more difficult for us. Okay, well, that's something I'd like to know, and then figure out how do we meet some of those challenges and put a price tag on them in order to, perhaps meet that need. And that can be, any kind of example that you're looking for. Folks might say, I would like to go back to school, or I want to make sure I return to this particular job. And you're trying to figure that part out for them. But all too often, we don't dive deep enough into some of those questions about their everyday life. And I really think that's where you can meet folks on the non-economic damages playing field and hopefully have a more informed discussion about it.
Super interesting. So I would like now to move a little bit out of the data field and ask you questions about how a trial happens. In the litigation, there are two buzzwords that often are used in the market, particularly for the plaintiff side: anchoring and reptile theory.
Yes.
First, maybe you should explain everybody what are those basic concepts, and then your opinion, are they still valid or outdated?
So I'll start with the reptile, which has been sort of in our vocabulary or so for about 10, 12, 13 years, something like that. And generally speaking, the reptile theory is designed to incite portions of people's brains based on psychological research and have them feel some sort of internal fear that general safety measures are being violated and that is a reason to find in favor of the plaintiff. And so it tries to establish a set of rules that are not necessarily evidentiary rules, but societal rules that should be followed and may have been broken. And over the last several years, there's been plenty of challenges to that, and it's not uncommon for trial lawyers to file a motion that prior to trial to exclude reptilian tactics, and they're often called reptile motions. Um, so it continues to exist, it continues to work, but it's received some 2.0s and 3.0 updates and starting to be given different names. And I could give a variety of sort of theories as to why it may have new names or new brands, but the general concept is still there and still employed. On the anchoring end of things, that's an issue I spend a lot of time on and certainly incorporate into my practice. The concept of anchoring is really, when you boil it down, is the suggestion of numbers in order to set a value on the case. And the research behind it saying, well, if I suggest at least $25 million for something, there's a stronger chance that as I repeat that, I'll come close to that 25 million if I don't actually get there. It might come out at 20, but if I started out suggesting 10, I might only come out at 8. And then there, of course, is the flip side of sort of gravity-based anchoring where that can come down. And those are topics we talk about every day, as you sort of pointed out in your question, Frank.
Okay, okay. So the subjects of those Casualty Connect video series are the intersection with AI and casualty insurance, or MedMal in your case. Before moving right to the AI, any kind of changes you would like to focus on, which may be new sources of information or new damages models for cases, any changes before moving to AI?
Yeah, so I think some of the changes that have really been on my mind have really been the organization of some of this data, right? I'm kind of previewing our AI discussion when it comes to that. It's all kind of out there to go and find, let's say, the hospital prices that we talked about earlier, but it is in such a kind of mishmash, terrible format that harvesting and kind of bringing that into those cases, making it presentable are the types of things that we're after every single day because the information is correct, the information is valuable, and it's that kind of aspect that we want to see brought into the courtroom in a presentable way. And that's one of the changes we're looking for. One of the other changes that are certainly on our minds and really relevant for both of our industries is getting as much comparable case data together that can really matter. And that is always a challenge and always a change we are kind of out there seeking. And I'm kind of crossing my fingers for on a daily basis.
I see. Okay, okay. And so now, where does AI fit into this litigation framework?
Yeah. So it fits in a variety of places, right? Where I think that the idea of AI being able to analyze past claims within a given system, right? Whether it's within a law firm, whether it is within a hospital system, whether it is, within an insurance carrier is gigantic, right? And really matters. I've had the experience, from time to time of on my cases, asking, a client that I'm working with, hey, what were the last 5 cases like that you had with this particular opponent? What was sort of the history there? What was the outcome of the case, the verdict or the settlement or whatever the case might be? And Well, I often find that they've got to go spend a ton of time looking that up and really culling through it to come up with an answer for that. I think AI could do a lot to address that sort of history and use that history for the present case that's before them. And I think there's tons of value in that we're just kind of all begging for. We often go and do verdict searches and look up headlines and use some of the other platforms that have verdict search information. And that has its place. It it's one piece of the puzzle though, and can't necessarily beat, the internal analytics and available data that might be there for a given system, especially if the system is large. That really just has, such tremendous value to me. Then kind of the other aspect, Frank, I'll kind of make fun of lawyers for a second. There's the old lawyer joke where they say, I went to law school so I didn't have to do math anymore. And I am sure plenty of lawyers like myself would say, boy, if AI is looking through other cases and giving us some calculations for maybe what an economist is projecting for a case, or calculations on what a life care planner is projected for 20 cases like this, or 50 cases like this, or whatever, and continue to kind of generate models that are informative based on similar cases and providing numbers and mathematical calculations for that are based on this underlying data. There's going to be a lot of happy lawyers that kind of take a look at that and say, I'm sort of glad I didn't have to do that math. I appreciate that. Because I do hear that joke a lot, and it definitely has been around a long time. And there's clearly a need in which to do so there. I also could see, just kind of adding to this, AI looking at some of the health insurance data in a given file that we've collected and projecting, what the totals are, how they compare to other aspects of the case, how they fit into the overall damages model of the case, helping to put those pieces together and give a framework to folks who are evaluating the case, either on the claim side or on the outside counsel side, and be able to do that, obviously quickly. That's the last element of all of this. Is a lot of what I've spoken about is time consuming. A lot of it is cumbersome. A lot of it comes from disparate places where you're just trying to get little pieces of data to work for you. But the AI obviously has a way of solving that and making that easier. And that's where its hope and its value is so tremendous. And you can really see a bright future for it there.
Thank you, Tom. So we are now towards the end of our conversation, and I would like to share some final thoughts with you. I would like to offer one, and maybe you can offer our audience more. Most of your practice, or a lot of your differentiating strength, is data. You mentioned many times in this conversation. And on the plaintiff side, we know that they have been sharing data for decades, and probably that explains part of the success they eventually join. On the defense side, it's not quite the same. As we have observed in our clients, probably the same with your clients, they are very, very reluctant to share any data. There were some attempts of federative learning, which were more or less successful, but not really finally successful. And so the question I would like to ask you is, how is it possible to improve performance without sharing data from the defense point of view?
Sure. So I would certainly wish that we shared more data. Let me say that at the outset, because I think there's plenty of value in doing so, and I do not think it harms business in which to do so. I genuinely think if there was more cooperation on the defense side from a sharing perspective, it would be to everyone's collective benefit. However, in order to answer your question, how do we succeed that way? To me, the best way in which we succeed is to start using some of these tools and at least share how the tools work with each other, even if we don't want to share the underlying data, right? And so, you know, work that your company's doing, for example, and letting folks know this is how you can at least harness the data that you're keeping to yourself, and this is how it can be useful to the industry is one way of doing it. Letting folks know something a little bit about what I do and say, here's where we're getting some of our information from. Here's what it looks like, or at least I'm going to be willing to give you an example of how we go through and add data to our cases that results in meaningful outcomes. This is what it looks like. And then I think the other piece of encouragement that I'm hoping to give to the industry is to say, you got to let your guard down a little bit. There's a couple of things we have to do a little differently than we did before. Obviously, we hear about AI every day in the news, one way or the other, and certainly we're hearing about it in this context, which I like very much. You're going to have to embrace it a little bit. My hope is that when you embrace something like that and you see the power of data working through an AI landscape, you might begin to think about what sharing with somebody else might look like, right? I am hopeful of that. And I am also hopeful that folks will embrace the idea that data as a concept inside of proving damages models and cases has to begin earlier in your case. And if it starts to begin earlier, then hopefully you get a little more comfortable with it. And if you get a little bit more comfortable with it, you're a little more comfortable with sharing it and making that more of a message for everybody to kind of understand. We we will only be effective if we're using the tools properly. And if we don't want to share everything, we should at least be using a lot of the same tools in a lot of the same ways, because I think that is at least one level of cooperation that we can operate at.
Yeah, sharing the methodologies, if not the data, at least.
That's right.
Thank you. Thank you very much, Tom. That was really a fantastic conversation. Thank you for sharing your thoughts and experience in this matter. And that was Casualty Connect, our video series on the intersection between AI and the P&C industry. We'll see you soon. Bye bye.
Thank you very much.